Good morning, everyone.
It's not morning. It's the afternoon. What you doing talking about morning?
Because I'm in a different time zone. That's right. Twilight, midnight, daylight, don't matter. It's whatever I says it is.
Who do you think you are? Gonna sit up here and tell me what time?
Because I'm going to be whoever I want to be. Now shut up and listen.
You be telling me that.
I said shut it up. Ladies and gentlemen, welcome. We're creating a song. It's called Decree by the Accused, Double Jeopardy. And this is talking about one thing. I want to bring it to your attention. I don't think there could have been information put out there that can help individuals who are incarcerated, who are having their rights.
But they did a crime. They deserve to be in jail.
Yes, 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 yes. You violate someone's rights. You violate the Bill of Rights. See, individuals have rights. We all agree that the Bill of Rights is what it is. You cannot harm another person. You harm another person, and there is no right to harm another person. Pay attention. The Bill of Rights don't give you the right to harm another person. You have the right to defend yourself. Okay? You have the right to protect yourself. Even the scriptures recognize you have the right to protect yourself. But you don't have the right to cause harm to another person, to take another person's property, to interfere with another person's right of self-sovereignty. I don't care if you're a judge. You don't have that right. What the judges have done since 1984, as I told you, nobody brought this to my attention. I didn't read the Sentencing Reform Act of 1984. I didn't read that until 1997. Well, 1998. Sorry, I keep making that mistake. 1998. When I read it, I picked up on the fact that the Sentencing Reform Act and the Sentencing Commission said that probation is a sentence in and of itself. It came from a case in Arizona, Harrison versus the state of Arizona, where the Supreme Court of the state of Arizona, and I said 1998, no, 1999, at the end of 1998, 1999. I remember it like it was 30 years ago. Ladies and gentlemen, the court had sentenced me to probation and incarceration. But the plea agreement worked out to where I was to do 1 year and then probation. That was the plea agreement. I was ready to do that. Okay. But the court says, oh no, we're going to give you 1 year county time. Now, if you've ever done county time, you understand county time is worse than state prison. And so that's what they did. They played games with me. So I did my research and I found that I could reject probation and just max out my sentence. Well, it was my first offense. The maximum was 2.5 years. I'd already done a year. I could only do the minimum because it was a first offense. So they would have to release me the next day after the hearing. But the judge saw what I was doing and said, I'm going to give you another year. And I'm like, you mother. And the judge, like, and that's it. Her name was Linda Akers. That whole, I hope she's dead now. I'm not joking. You see, I have no respect for any judge who violates the law and know that they're violating the law and violate someone's rights. The same rule applies to them. I don't care what you think about what I just said. The same rule applies to them as applies to me and you. You violate someone else's rights, due process rights, Bill of Rights, then you've committed a crime in the United States. That is the law. You don't believe me? Go back and read the Bill of Rights. The Bill of Rights protects individual rights, doesn't protect group rights. It has nothing to do with the group. It protects the individual rights. That's why it's we the people in order to form a more perfect union to ensure domestic tranquility, provide for the common person's defense, to promote the general welfare of the person, to ensure the blessings of liberty. You can't establish Freedom for a group. You can only establish freedom for the person. Do ordain and establish this Constitution for ourselves individually and our posterity individually. Go back and read it from that standpoint. Now let's talk about something. The Sentencing Reform Act of Congress, they had a floor debate. This was a so-called bipartisan decision. This is the original Judiciary Committee report. It emphasizes probation and imprisonment are mutually non-compatible. They are separate. Okay? They are separate. They said that they prevented stacking them together. Oh, I'm sentencing you to 5 years probation in addition to 10 years incarceration. They can't do it. Now remember, Congress created probation. It was never in common law. Congress created that. Well, they got to do probation when they get, no, they don't. The punishment for the crime is the deprivation of liberty. That is the punishment the 13th Amendment recognizes. No one may be subjected to involuntary servitude unless for the conviction. You can only be convicted to imprisonment or probation or parole. You cannot be convicted to all three or two at the same time. It's illegal. It violates double jeopardy. Okay? Double jeopardy is a principle. Pay attention, not a clause, a principle. And it has nothing to do with the 14th Amendment. People keep thinking the 14th Amendment is the thing that applies to the states. No, it doesn't. The 14th Amendment created a federal citizen. You don't believe me? Go read the slaughter. It's called Slaughterhouse Cases. And then go read Grisham. Now, anyway, let's continue. Now, the statutory construction evidence, see the unless clause, they said unless, that's the one to focus on because that's the one I focused on, uses a mandatory language, meaning may not, unless, okay? A person may not be sentenced to probation unless, which the Supreme Court has held, creates a categorical limitation. They've already, pay attention, people. They have already made this choice and decision. I've been trying to highlight this to people since I found out about it. I've been raising it every single time. Now, they've been ignoring me, but I haven't been trying to push it like I'm about to now. I just want to let y'all know. Let's do one more thing. This is the Senate report, Senate record. Let's find out what the Senate had to say. Because you know how the Senate is. They open and close their mouths, talking about the big, beautiful bill. Talking about the big, beautiful bill. Talking about, pay attention, Trump said he wanted it passed by the 4th of July. He's going to sign it on the 4th of July. Now tell me that ain't scripted. Shh, don't tell nobody. Everybody's sitting up there watching that junk and believing that junk. Lord have mercy. Ladies and gentlemen, this is the original statute. Sentence of probation. They tried to do the U.S. stupid code junk. Ladies and gentlemen, here is the unless part. A defendant who has been found guilty of an offense may be sentenced to a term of probation unless, let's go down to number 3, the defendant is sentenced at the same time, simultaneously, double jeopardy, to a term of imprisonment for the same offense. Don't worry about or different. Pay attention. They may be sentenced to probation unless they have already been sentenced to imprisonment, is what this says. They cannot be sentenced to both. Aight. Okay, probation is a separate sentence. The bill makes clear that probation is a sentence in and of itself, not a suspension of imprisonment. Probation is a sentence. Get it in your heads. Section 8.3, the one we just read that had the unless provision, prohibits sentencing a defendant to probation if they received a term of imprisonment. other than for a petty offense. What is a petty offense? It's one that doesn't carry prison time. Duh. This ensures that probation and imprisonment are mutually exclusive, meaning they're not the same thing. One of these things is not the same thing. Which one of these things is not the same? That's the point. Gotta let y'all go. Go and read those notes from Congress. I put it in a song. I'm not gonna let you hear it. You're gonna have to go watch the video. Gotta go. Take care.